Good afternoon, everyone. My name is Joseph Kearney, and it is a privilege for me as Dean of the Law School to welcome you to Marquette University Annual Nies Lecture. I do this on behalf of my faculty colleagues specializing in intellectual property law, in particular Professors Bruce Boyden and Kaylee Murray, and indeed the entire law faculty. Let me begin by remembering the person in whose memory this lecture stands. Marquette University Law School created this annual lecture series in 1998 to honor the late Helen Wilson Nies, who had served as a judge of the United States Court of Appeals for the Federal Circuit from its creation in 1982, and previously on the U.S. Court of Customs and Patent Appeals. We did so at the suggestion of our then colleague, Professor Craig Nard, who secured the enthusiastic assent of our community and Judge Nies's family. Craig had had the privilege of clerking for Judge Nies, and he remembered her to us as a very generous individual and a serious, modest, and hardworking judge. Over the years, then, we have been able annually to host a distinguished leader in intellectual property law as our Nies lecturer. That is especially so this year. The Honorable Kathleen O'Malley is herself a judge of the U.S. Court of Appeals for the Federal Circuit, where she has served since 2010. She is a tremendously experienced judge, both generally, having served on the U.S. District Court in Cleveland from 1994 to 2010, and in intellectual property cases, having presided as a district judge in more than 100 patent and trademark cases. She is committed as well to legal education, as we see from her longtime service on the adjunct faculty at Case Western Reserve University Law School, and on the faculty of the Berkeley Center for Law and Technology's program designed to educate federal judges in the handling of intellectual property cases. Those institutions can claim her in some sense. The judge received her J.D. from Case Western, earning Order of the Coif Honors, as can Kenyon College, from which she graduated magna cum laude and Phi Beta Kappa. So too, now, can we at Marquette University Law School claim her, for the judge has done us a great honor by traveling to Milwaukee to speak today concerning the state of patent litigation and to answer questions afterwards. This is a somewhat different topic from the one originally noted, as we informed all who registered for the lecture, and I am delighted about all of this. Please join me in welcoming this year's Nies lecturer, the Honorable Kathleen O'Malley.
Thank you. Okay. Thank you. Whoa, that's loud. I noticed the IP professor sitting in the front row. I asked if they were here to heckle me, but every time I stand up to speak after an introduction, I always remember the story that I heard about Golda Meir, who was sitting on the dais when an honoree was about to get up and receive an award, and after the honoree was introduced, he went to stand up to get the award, and she grabbed his arm and said, "Don't bother to act humble, you're not really that great." So I'm actually really privileged to be here to give a lecture in honor of Judge Helen Nies. She was the first woman appointed to the Federal Circuit and the only woman to date to be its chief. Though I did not have the opportunity to get to know her before she passed away in 1996, all four women currently on the court know that she blazed a trail for us. At her investiture to the Court of Customs and Patent Appeals, which was one of the predecessor courts to the Federal Circuit, Judge Nies said that she hoped her service on the court would inspire other women to consider undertaking the same challenge. No doubt she would be pleased to see 1/3 of the seats on the current court filled by women, and be thrilled to see how many talented young women are now entering the intellectual property field. In preparing to come here today, I thought that I should learn something more about Helen Nies, at least more than what her statistical firsts on the court were. I wanted to get a sense of the person whose name you all invoke every year at this time. So I read the transcripts of her investiture to the court in 1980, her investiture as chief judge in 1990, her portrait ceremony in 1993, and her memorial service, sadly, only 3 years later. And while I, of course, learned a lot about her impressive background and education and generally about her years of service on the court, I was also able to capture a glimpse of the person that Judge Nies was. And in reading what others said about her and attending to her own words, I was actually shocked to see how much she and I have in common. So let me just name a few. We both grew up and went to college and law school in the Midwest. We were both economics majors as undergraduates. We both waited tables while in college to help put ourselves through. We were both devoted daughters. We both had children while practicing law and threw ourselves into raising them with such zeal that it was sometimes annoying to our children. We both loved physical activity and apparently staring at the water. We both loved singing, though she actually was able to do it and didn't mind doing it in public. We both cherish our non-lawyer girlfriends because they help give balance to our lives. We both love to entertain and host parties, especially where champagne is involved. We were both in private practice and government service before taking the bench. Neither one of us was a patent specialist when appointed to the Federal Circuit. She was a trademark specialist, and I was a district judge who, by definition, has to be a generalist. We both do our best legal writing at the kitchen table. We both have strong bonds with and an appreciation for all that our law clerks and judicial assistants do for us. And most importantly, we both love being judges, love the law, and work very hard, not just to try to do the work of the court, but to try to do it well. So I hope that Judge Nies is looking down and rooting on her kindred spirit. And I hope my years on the court will someday be remembered as fondly as hers. So now I'm going to turn my attention to the work of the court. And I start with an apology for having to change the topic of this lecture. While the dean was very gracious, as he just was again, when I told him that I had to do this, and I know it did cause some scrambling, and so I apologize for all of you in your shift in expectations. As you know, I originally intended to speak about the importance of reviewing the efforts of district court judges with deference, a topic which is near to my heart given my 16 years as a district court judge. And it's a topic that I know happened to be important to Judge Nies, which is one of the reasons I thought of it. But at the time I suggested it, I did not anticipate the fact that a mere 2 weeks before coming here, the Supreme Court would grant certiorari in Teva versus Sandoz, and that the only question presented on which cert would be granted is whether the Federal Circuit may continue to review all aspects of trial court claim construction determinations de novo. So while I knew that the matter wouldn't be before our court anymore, as it had been en banc in the lighting ballast case, I had no idea the Supreme Court would jump the gun and take the topic. So because it's now squarely presented to the Supreme Court, it's off limits for me, at least for now. Instead, I'm going to focus on the Federal Circuit's shift from a relatively little-known court to one whose work in the intellectual property field has become the focus of all three branches of government, an increasing number of increasingly vocal academics in the field, reporters, and yes, even bloggers. I don't mean to imply that it's the judges on the court who are garnering or deserving all this attention. It's actually the change in the nature of patent litigation that has begun to shine the light on the court. There's been a change in the volume of patent litigation, the nature of the parties engaging it, the law firms representing those parties, the impact of patent litigation on the individuals and entities involved in it, and in the importance of patents to our economy as a whole. All of these changes have caused many to take notice of the work of the Federal Circuit. Some of that notice welcome, some a little less so. Now I'm going to touch on each of these changes briefly, and then I'll talk about the attention that the other three branches of government are giving to the work of our court. I will leave it to the academics to do an empirical study on the changes in their ranks and their attitudes toward patent litigation. And on that score, I do just want to note, though, I've seen more amicus filings from academics, and in those amicus filings, I've seen more academic institutions or a greater variety of academic institutions represented. And I'm also going to leave the reporters and bloggers alone in the hope that they might do the same for me. So the Federal Circuit was formed in 1982, which was coincidentally the year I graduated from law school. So I obviously didn't learn about the Federal Circuit in my first year civil procedure class. And Case Western, back then, like most schools, didn't have a patent law class or a patent litigation class where perhaps the thought of forming the Federal Circuit might be discussed. And while clerking on the Sixth Circuit, I had no occasion to come across or care about what the Federal Circuit was doing or saying. It was not until I started practicing law at Jones Day in Cleveland and was tasked to work on a number of patent cases that I learned about this strange circuit, the only one whose jurisdiction is based on subject matter rather than geography. And I soon realized that I was among a rarefied few in the legal profession who knew about the Federal Circuit or the scope of its jurisdiction. I mean, it's a little tough when you go out to a cocktail party and people ask what you do and you start talking about patent litigation and they give you a blank stare. And these are practicing lawyers. So in the first year of the Federal Circuit, they entertained appeals from district court cases in only about 170 times. It's hard to tell exactly because back then they didn't keep track of the difference between patent cases coming out of district courts and what we call Little Tucker Act cases coming out of district courts, which is a small percentage of cases coming out of district courts, but it's something else out of district courts that the Federal Circuit had jurisdiction over. We're now keeping track of them separately, but they didn't back then. So that 170 cases, that was despite the fact that they had nationwide jurisdiction over all these district court cases. And this low number, to some extent, is probably reflective of the fact that in each of the 3 years prior to 1982, there were well fewer than about 1,000 patent cases filed in district courts nationwide. By the time Judge Nies passed away in 1996, which was 2 years after I took the district court bench, the number of appeals had risen to about 350, and the number of patent actions filed in district courts had risen to about 1,800. At this point, patent appeals challenging U.S. Patent and Trademark Office decisions numbered around 80. Fast forward to 2012 and 2013, where the Federal Circuit entertained appeals from district court judgments in an average of 500 cases during each of those years, and district court patent filings rose to, I kid you not, 5,189 and 6,497 respectively. At the same time, appeals from the PTO decisions were up to 132 in each of those 2 years, and we expect hundreds more appeals from the PTO in the next few years arising out of new post-grant proceedings that were authorized by the America Invents Act. Now, while federal filings in complex cases generally have gone down, the patent litigation business is booming. Indeed, patent filings in district courts have almost doubled from 2010, when I came on the bench, when there were 3,300 patent actions filed, to 2013, where, as I said, there were almost 6,500 patent cases instituted. And notably for us, the approximately 500 appeals that we entertained in 2013 arose from cases instituted several years before that, where the district court filings were much lower. So assuming the appeals pace keeps up with the increase in the number of filings, even to some extent, appeals and patent actions out of the district courts will likely skyrocket along with those out of the PTO. But it's not just the numbers that are important. As with all things, quality and character of the patent litigation we are seeing is as meaningful as its quantity. Many of these patent cases are being filed today by patent owners who do not actually practice the invention that is the subject of the patent that's allegedly embodied in the product or method they attack. Some of these actions are filed by what have been variously referred to as non-practicing entities, patent assertion entities, or the favorite term in congressional hearings these days, trolls. And trolls are generally, it's a definitional problem because it's hard to say what are non-practicing entities. Obviously, a university would be as well. But trolls, as it's used in these congressional hearings, are generally considered entities who purchase patents for the purpose of generating capital by enforcing them. A recent General Accountability Office study estimates that about 20% of patent cases are prosecuted by non-practicing entities, though many scholars have estimated that this is a low number or low estimate. Now, this monetization of the property rights reflected in patents is new and results in the enforcement of patents which in years past would have remained dormant. Passive rights, which owners either did not have the wherewithal or the desire to enforce. And many assert it results in the enforcement or efforts to enforce or threatens efforts to enforce undeserving patents, which either never should have been granted or are no longer relevant. And those numbers don't take into account, moreover, active companies who do practice some patents that they own, but then enforce other patents that they either never practiced or don't practice anymore because their own technology has moved on. Again, this is generally new. In the past, competitors tended to only worry about those competing in the exact same space with the same technology. Now patents are seen as a way to prevent competitors from catching up, from using the same building blocks to eventually arrive at the same place. And this seems particularly true where computer-implemented software patents are concerned. Now, this litigation is also often brought in parallel with actions before the International Trade Commission, stretching resources of those sued and upping the ante with the threat of a possible order barring the importation of what could be a company's key product or key component of their products. Indeed, ITC appeals to our court have also gone up. They used to be just a handful. They've now averaged over 20 a year in the last 5 years. And patent actions often include claims against a corporation's competitors. So many competitors are brought together and there's sensitivity about how they're going to defend collectively. And they also often bring in manufacturer's customers, which creates a lot of business problems and business interferes with business relationships. But the change in the nature, this isn't the only thing that's changed. There's a change in the nature and the number of law firms litigating these matters. And that's meaningful as well for a couple reasons. Obviously, it tells us some things, and it's not just meaningful because with big law firms tend to come big fees. There's more to it than that. When I started practicing, Jones Day was one of the few general purpose firms or general practice firms that took on patent litigation. It was then largely the province of boutique law firms who did prosecution and litigation and nothing else in the patent arena. Even when I took the bench in 1994, the law firms that I was seeing trying patent cases were not the same firms that I was seeing trying other complex cases or complex civil cases in my court. But today, I would venture to guess that very few large general practice firms don't have thriving patent practices, and those that don't are probably trying to create those thriving patent practices right now. And as I said, this is important for a few reasons. Of course, it reflects the fact that patent litigation has become more mainstream, and it also reflects the extent to which traditional large firm clients are repeatedly being drawn into patent litigation. And it reflects the high stakes now involved in these matters. It's not unheard of to see damage verdicts that exceed $1 billion, and many approach $100 million or more. Big firms are responding to the needs of their clients and the fears that those clients have of being hit by these large awards or being hit with injunctions that could bar the sales of their main or most profitable product, or on the other side of the fear that a client might have of losing a legitimate patent advantage in their particular industry. But the presence of general practice litigators in the mix is important for another reason. They are experienced in trying cases in all manner of fields and in all courts. And they are experienced in arguing a variety of civil cases before the regional circuit courts of appeals. As a result, instead of being just specialized patent practitioners, they have a generalized knowledge of how the federal rules of civil procedure and evidence are designed to work, how principles regarding jurisdiction and venue are to be applied, of governing common law concepts, and of what the relationship between the trial court and the appellate court is supposed to be. That means they have less tolerance for treating patent cases differently than other cases when it comes to these basic principles, and are more comfortable challenging the Federal Circuit and the Supreme Court when the Federal Circuit creates special rules for patent cases. Now, at the same time, patent litigation has become a more popular tool for challenging competitors and a more popular funding source for venture capital firms, the scope of available e-discovery has exploded. People blame patent litigation on this. No, it just so happens that they both happened simultaneously. Of course, in all cases, we have today emails, backup files, metadata, and other potential sources of information that litigants can and do seek to obtain. So that means that the costs and burdens of discovery in these cases have increased at the same time that the stakes have increased. Some studies indicate that the average fees and expenses in a patent case are over $5 million, and in complex cases, they far exceed that. So corporations are feeling the financial burdens, and general counsel can no longer ignore the part that patent litigation plays in the company's legal budget. Where in-house patent counsel were once deemed either unnecessary or were left to their own devices given the little world that they were playing in or the unique world that was their litigation, they are now critical players in the corporate hierarchy. It's impossible to go to patent-related conferences or a conference on IP litigation and not hear complaints from in-house counsel regarding the costs and structural burdens imposed on them by costly, high stakes, and now somewhat constant patent litigation. So we have the one side of the coin. Patent litigation has blown up, and it has become more costly, more burdensome, and more frightening to corporations. But at the same time all this is happening, we see that the need for legitimate patent protection for true inventors has been heightened. As we have become less capable of competing in the manufacturing arena or the energy sectors, American ingenuity has become the primary driver of our economy. It's our ability to conceive of a better mousetrap, to continually be one step ahead in the technology space, and to lead in medical research and development, which keeps us competitive in the world. Thus, while complaints about patent litigation and its attendant costs and burdens abound, few would debate that a robust patent system with meaningful mechanisms to protect those patent rights is necessary to foster innovation and protect often substantial investments innovators must make. In a recent conference I attended, I heard the founders of Oracle explain that while they are now the victim of what they perceive to be unfair infringement claims by non-practicing entities, they recognize that Oracle owes its very existence to the patent protection upon which it was able to rely in its early days. And at that same conference, I heard the inventor, Dean Kamen, say that though because he loves to invent but not to manufacture, one could probably characterize him as a troll, he knows he could not afford to continually come up with new innovations, most of which are in the medical device field and so are important to many of us, without knowing that he could get patents on his inventions, which he could then sell and hope to recoup his costs and fund his next effort. Similarly, those conducting pharmaceutical research and development will tell you that the cost of developing, testing, and getting regulatory approval for new drugs is so prohibitive that it would not be undertaken but for the promise of patent protection that offers at least the hope of recouping some of that outlay. So we're now in a world where patent litigation has become overwhelming to many business owners at the same time that appropriate patent protection has become even more important to our economy. Sort of like the old saying we women have for men, you can't live with them, but you can't shoot them. That's where we are. And it's at the center of this vortex that the Federal Circuit finds itself. So we on the Federal Circuit have responded. We've decided 6 patent cases en banc since I took the court at the end of 2010. TiVo versus EchoStar regarding the authority that district courts have over contempt proceedings. Therosense versus Becton Dickinson regarding the standard for proving inequitable conduct in patent cases. CLS Bank versus Alice regarding the patentability of computer-implemented software and method patents. Akamai versus Limelight regarding indirect infringement. Bosch versus Pylon regarding the scope of our jurisdiction over certain types of patent appeals. And Lighting Ballast versus Phillips regarding the standard of review for claim construction. But even outside the en banc context, our court has made progress and made efforts to clarify difficult issues arising in patent cases. Our jurisprudence in the standards and burdens imposed where a patent claim is challenged on obviousness or enablement grounds, on the appropriate measures for proving damages in patent actions, on whether and when permanent injunctions remain appropriate after a finding that a patent is valid and infringed, on the standards to be employed when a request for fee shifting is made under Section 285 of the Patent Act, and on when the plaintiff's chosen venue is inappropriate has all come a long way. And these are not the only areas where we have worked hard to incrementally clarify the law in response to the increasing number of patent appeals we hear and the increasing complexity and contentiousness of those appeals. But as I noted at the beginning, we're not the only ones who are paying attention. We're not the only ones who recognize the importance of intellectual property disputes and intellectual property law. The Supreme Court has shown an increasing interest in the area and in the cases we are deciding. Recent years have seen an unprecedented willingness by the Supreme Court to wade into patent actions within the Federal Circuit's jurisdiction. In the first decade of the court's existence, the Supreme Court took 18 cases coming out of the Federal Circuit, only 5 of which were patent cases. While the number of patent cases going to the Supreme Court increased somewhat over time, in the first 28 years, and I use this number because that's from when it started to when I took the court, the Supreme Court granted cert in 51 cases out of the Federal Circuit, only 22 of which were in patent cases. Between 2010 and today, the Supreme Court has taken 22 cases from our court, 17 of which are in patent cases. And it took 1 case from state court, Gunn versus Minton, for the purpose of unanimously overruling Federal Circuit precedent regarding its jurisdiction over state law patent malpractice claims. And to show just how dramatic this shift is, about 30% of the cases which went from the Federal Circuit to the Supreme Court during Judge Nies's tenure on the court, her entire 16 years, were patent cases. In my 3.5 years on the bench, 77.3% of the cases arising out of our court and ending up in the Supreme Court are patent cases. To give you another metric, in that first 28 years of the Federal Circuit's existence, patent actions finding their way to the Supreme Court made up on average less than 1% of the Supreme Court's total docket. In the last 3.5 years, patent matters make up over 5.5% of the Supreme Court's docket. Now, some of the cases out of the Supreme Court in the more recent years seem to be sending a general message about how the Federal Circuit should operate. eBay, KSR, MedImmune, even the recent Medtronic decision are all generally seen as instances where the Supreme Court has been telling the Federal Circuit that as an Article III court, it is bound by the same rules, civil rules, jurisdictional standards, and common law principles that govern all Article III courts. In other words, the patent litigation is still just litigation, and it's supposed to be treated that way. But the Supreme Court's gone further, especially lately, wading into highly technical matters such as the patentability of business method patents, patentability of software patents, and even patentability of even aspects of DNA mapping. We are currently awaiting decisions in 5 cases for this term and a 6th on the docket for the next term. The cases involve an analysis of what constitutes patentable subject matter under Section 101 of the Patent Act, what standards govern claims of indirect infringement, what measures should be employed to determine whether claims are indefinite and thus invalid, what considerations should impact district courts' assessments of fee applications under Section 285, and what standard of review our court may apply to those decisions, and finally, as noted, whether the Federal Circuit can continue to review claim construction de novo. So the Supreme Court has shown a heightened level of interest in what our court is doing in the patent area and in whether we are doing it correctly. Supreme Court dictated changes in the legal standards the Federal Circuit must apply, or in the governing standard of review we may employ, may impact the Federal Circuit's jurisprudence across a wide spectrum of cases. In fact, all this Supreme Court activity makes it hard for me to come up with substantive speech topics, and so many are now off limits. It's not just that the Supreme Court's scrutinizing the matters that come before us and is recognizing the issue of how important it is, so are the other 2 branches of government. The President of the United States has taken an interest in patent litigation. He even mentioned the need for a stronger patent system to foster innovation in his State of the Union address this past January. I've asked virtually everyone I know if they've ever heard a president mention patent litigation in his State of the Union address, and nobody could think of a single time. But he did this year. And these comments echo other White House announcements regarding the need to address abuses in the patent litigation system, and to streamline the costs, while at the same time being cautious not to curb the innovation that the strong patent system can further. And the White House has actually created a special in-house position within the Office of Management and Budget that's called the Intellectual Property Enforcement Coordinator, whose function is to coordinate the efforts of all governmental entities to combat intellectual property theft and foster innovation. Now, both because of White House calls for reform and because of their own independent concerns, Congress has also shown a willingness and an apparent unending desire to redefine the patent laws in ways not done since the important passage of the Patent Act in 1952. The America Invents Act, to which I alluded before, was signed into law on September 16, 2011. And the changes brought on by it are sweeping, creating new classes of actions for challenging the validity of patents before the PTO, and thus creating a whole new platform for appeals to the Federal Circuit. That legislation also set up a patent pilot program through which district judges can opt in to handle a greater number of patent cases. I think the concept is with greater experience comes greater expertise and greater efficiencies. Now, while the AIA took 7 years to negotiate and pass, and it hasn't even been afforded the test of time yet, we're seeing new proposals for even more patent reform, with one bill having already passed the House, and at least the rumor is that there's one ready to go to the Senate floor as soon as the Senate comes back from their spring recess. I have to say, when my secretary was typing up my notes, she said, "Wouldn't it be nice if we could have a spring recess?" And so, but anyway, so the new legislative initiatives, though, in Congress are a bit odd. They seek to address and change the way that patent cases are actually conducted and litigated in the courts. So rather than make substantive changes to the patent law, Congress is currently considering legislative proposals whose avowed purpose is to curb litigation abuses by telling courts what they have to do when they have a case before them. Their apparent primary focus is on how trial courts manage patent cases, and they dictate everything from pleading requirements to the extent and timing of discovery, telling judges that they can't do discovery before Markman hearings, and to the extent and timing of stays against certain parties to litigation. They even tell district courts whether and when to shift fees under 285. Now, and these proposals, at least the one coming out of the House, if that stands, or if most aspects of that stand, would even go so far as to tell the Supreme Court that they have to change certain rules of civil procedure and to direct the administrative office to expend resources to study patent litigation and how patent litigation is conducted. Now, these bills raise questions regarding the appropriate respective roles of Congress and the courts in managing litigation. At least they have for me. And I have spoken a number of times on what I consider to be a problem with a separation of powers problem with these bills. But for purposes of my point today, the debates actually in Congress, instead of focusing on whether they're stepping on the toes of the courts, which is something that I don't think many people in Congress care whether they're doing, but the debates actually do focus more on the tension I mentioned earlier between a legitimate and actually now somewhat frenzied desire to curb litigation abuses by a certain class of patent litigants, and the need to maintain the integrity of the system for those who might legitimately need to resort to the courts to protect their intellectual property rights and the business interests that they further or which depend on them. And as those debates reflect, from a policy perspective, which very much is the province of Congress rather than the courts, there are no easy answers about how to balance these concerns. Unfortunately, I think they're trying to do so by tweaking the way we litigate cases rather than trying to really deal with this tension head on. But with all of this and all of this attention that we're getting from the other branches of government, in just a few short years, it seems that the Federal Circuit has gone from a court familiar to a specialized group of lawyers and a fairly limited number of litigants to one whose work has become more important to our national economy and which is now being scrutinized by all three branches of government. as I said before, I don't think it's the makeup or the work of the particular judges on the court that deserves the credit or the blame for all this attention. I don't think that for instance, that I'm making so many mistakes, that the Supreme Court is taking a lot more cases in the last 3 years than it did before. I believe it's the changes in the realities of the patent system and of patent litigation itself that have put us in the eye of this storm. And it's one that the Federal Circuit will continue to try to do our part to weather successfully. The one thing that I do know for sure is that the attention is not going to diminish anytime soon, and that I assume that from academics like those hecklers sitting in the front row, that we will get a lot of suggestions on how best to do our job and how Congress might continue to tell us how to do it better, or the Supreme Court. So with that, I'm prepared to take questions.
Thank you, Judge. We have a good 15 minutes or so for questions, and if my colleagues in the front row were not provoked at the beginning, I have to imagine they were provoked at the end. I mean, pretty well called out in that regard, but we will welcome questions from anyone in the room. To the extent, yes, please, can you state the question?
My question is, you said there's a problem. I was just, you mentioned about 6,000 cases a year, Judge.
Yes.
Where are all these coming from? I mean, once in a while we read in the business section or on CNN the real huge cases, but where are all these tiny little or these other cases coming from? I'm just curious. Thank you.
I think part of the reason that there is an increase, or has been an increase since the passage of the America Invents Act, is because there's some odd joinder rules. What you used to see is cases with 100 defendants in one case, and so now they are having to separate them into separate cases, though they don't all follow. A lot of the at least parties and even the courts don't seem to be completely following the joinder rules. But I do think that they are coming from the fact that many patents that aren't being practiced are now being enforced. In the old days, we just didn't see that. People only really tended to enforce patents if they thought their property rights had been stolen by someone, and that the only reason they weren't practicing it is because someone had really stolen that property right and stolen their idea, or they would be enforced if they wanted to practice in the same space and they were head-to-head competitors. So I really do think that this number increase, and it is even in much smaller circumstances against smaller players, which is one of the reasons I think Congress is concerned.
Other questions? Yes, if you could exactly hold that down while you ask the question. Thank you.
I have a question. I don't know whether you can answer this or not, but can you provide a little bit of insight? I'm intrigued by the Apple versus Samsung fighting going on, and if you could provide your thoughts on that, I'd be curious to know, instead of just reading the business and news sections all the time.
Yeah, in fact, that's one I definitely can't comment on. I don't know if you know, but I was on the panel of the last two Apple-Samsung cases that came up to the court, and to the extent that it arises out of the same action, it'll keep coming back to us. So, but you're right, it is intriguing. And I can say one thing, because this is factual. There is at least one of the patents that they're fighting over that Apple isn't practicing, which is one of the reasons I think that the lower court denied an injunction. I'm not expressing any opinion about the value of that, it's just a reality.
Yes, if you could hold the button down, and that way everyone will be able to hear you at the front of it.
In a lot of the discussions, both out of the White House and out of Congress, about patent trolls and then trying to address it by managing litigation, there's been comments about the quality of the patents that are being enforced, and the idea being there's a problem with patent quality. I wonder if you feel they're kind of missing the elephant in the room, in the sense that they talk about patent quality, but I haven't seen anybody talk about better funding for the patent office.
Yeah, I don't think the patent office is unfunded right now. I mean, I think they're making a lot of money, and what they're making a lot of money on is these post-grant reviews, and so those are extraordinarily expensive for parties to initiate, The one thing that you do see in terms of the numbers is that the Patent Office is invalidating a huge number of patents that its own people issued. That may reflect, you could argue that that's a poor scorecard for their examiners if their own people are later invalidating patents that have been issued. I think we have to wait and see what happens 5 years from now, because my understanding is that the PTO is working hard to improve what's going on at the examiner level as well. But I think you're right. It's not as much a funding issue as a focus. Let's focus on getting, good patents issued and only good patents issued, then a lot of this problem could go away. But I think right now what we're seeing is there was at least a history in the Patent Office that a lot of patents were being issued. Well, I have, for instance, let me give you a good example. I have a law clerk right now who used to be a patent examiner, and he told me that, and he was in the medical device side. He told me he had 12 hours. He was allowed to review a patent application for 12 hours and then had to give it thumbs up or thumbs down. That's it. That's ridiculous, and especially because it's fine if the medical device was a really simple thing, as it had been probably when those rules or timelines were created, but when you're getting extraordinarily complex medical devices, which he was getting by the end of his tenure, 12 hours is just not enough. And he was a young kid that was just, out of engineering school. So I think that there has to be a greater focus on the front end, as you said. I think there really does. I'm not sure, though, that it's a funding problem right now, because the PTO is allowed to use all this money that it's bringing in on the back end for purposes of funding the front end.
Other questions? Yes, if you could hold the button down in front of you so that we can all, the front of it. Right.
Right here? Oh, thank you. I haven't used it before. Your Honor, thank you for coming. The question I had was with regard to the Supreme Court becoming more involved in patent litigation, and I was curious as to your opinion. Is the Supreme Court getting involved because they want to sort of establish controlling precedent that might act as a baseline to at least direct future litigation, so it never gets to litigation in the first place, or is the nature of these patent suits so factually specific that it's a limiting holding? I'm just curious to see what your opinion is.
Yeah, well, it's funny. I was at an event, and during the cocktail hour, I ran into the Chief Justice, and I said, so what's the interest? Why are you taking so many patent cases? And he said, have you seen our docket? He said, we've got a lot of boring stuff. Your stuff's exciting. But
Did he really say that?
yeah, he did. This was a few years ago. But I think their motive is that they're seeing the same thing that I was just talking about. It's become a huge issue in our economy, and every large corporation is being impacted by it. Even small corporations are being impacted by it. There's tons of chatter on the Hill. I mean, the Supreme Court is inside the Beltway, whether it likes it or not. I mean, so it is hearing all of this discussion, and it's sensing that these things are really important. And as I said, we've got some of the best lawyers in the country. Former, solicitors general are now trying these, or handling these appeals, and they're going to the Supreme Court saying, this is something you got to see, this is something you got to do. And we have the current Solicitor General who's willing to weigh in on these cases. So I think the Supreme Court's, people are getting the Supreme Court's attention. I think the topic is getting the Supreme Court's attention. I do think you're right that sometimes it's dangerous to try to create general rules with very fact-specific issues, and that is, I think, a fear that the rule that what they'll lay down will be a little too loose for anybody to really understand what it means. But we'll just have to wait and see what they do.
Yes, if you could hold down the microphone, and that way everyone will be able to hear you.
Your Honor, sort of going to the non-practicing entities that you've mentioned, wondering if you have any views on whether the secondary market that has emerged for patents, be it sort of the common patent brokering, or even now traded exchanges in patent rights, such as the IPXI, if you have a view that that's a healthy thing for the patent system, or if it's fueling the problem?
I think that's one of those policy decisions that's beyond, what a judicial officer should really be weighing in on too much. So I can tell you that I think I doubt that Congress would ever step up and say, you can't transfer, a property right. It is a property right. It's a constitutionally endorsed property right. It's a governmentally issued property right. So I don't know how you fix that. There is a lot of talk about trying to figure out how to regulate it. And I think probably the only thing that we can do from, the district courts and the Court of Appeals right now is to make sure that you're carefully assessing whether the patents are strong patents, whether they're good patents. I think the place where it comes into play the most that I'm seeing out of district courts is in the remedy. If you're not practicing, you're less likely, obviously, to get an injunction. Of course, half of them don't care if they get an injunction. It's about the money, I guess. But so I don't really have a sense of whether it's a good thing or a bad thing. I've heard arguments on both sides, and I think the argument in favor of it is that there are probably a lot of little inventors out there who don't have the money to really enforce their own patents. And this is one way that their rights are actually being vindicated. That's the argument on that side. So I don't know. I mean, there are probably other people in the room that have stronger opinions about it. I've tried to avoid having too many opinions about it because who the party is, I'm not allowed to factor into my decision making.
Other questions? Yes, in the red, and then we'll move up one row, please.
There's a fair amount in the press about the legislature, Congress, looking at fee-shifting options as one way to control the flood of non-practicing entities. Yet in the federal circuit, and therefore the district courts, we're not really seeing much, if any, shift in the way that is applied. Does that reflect a difference of opinion as to whether or not that's appropriate, or is that more of a view that the role is more appropriate in one place or the other?
I think that over the years, district court judges have always tended, and I say this having been a district court judge, to believe the American rule is the norm, and that fee shifting, even fee shifting authorized by statute, is still something that you need to be cautious about. There's a sense, look, I just ruled in your favor, you won. Why do we have to go any further than that? So I think that district courts traditionally have been hesitant to do it. I think the federal circuit traditionally has been a little strict about the circumstances in which it could be done. We had a recent decision in Kilopass that said that the standards are not as tight as you would think. I think right now we're waiting to see what the Supreme Court is going to say, because the Supreme Court has two 285 cases right now. I don't know that it's more appropriate in Congress than it is in the courts. I think Congress may decide to wait to see what the Supreme Court does, but it is certainly something that's fixable by Congress, and it's a statutory provision, so it's certainly within its bailiwick. This is not the kind of things that I was complaining about in terms of the separation of powers. But I do think there's always been a hesitation in the trial courts over the years, just because of the way we were all raised in the litigation practice. You're careful about imposing sanctions on lawyers because it could destroy their careers. You're careful about fee shifting because the American rule is the norm. I think the part of it's a change in mindset that's needed.
And then one row up, please.
Based on your experience as a private practitioner, a district court judge, and an appellate, can you think of other areas of the law where there might be benefit to having a federal court model based on subject matter rather than geography?
Yeah, we were just laughing about this morning. We're talking about copyright. If you look at copyright law, it's across the spectrum of all the circuits. It's insane. I mean, it really is. Every circuit's different, and even within the circuits, the panels are different. For all the criticism that the federal circuit has, I think the reason it gets criticism is because it's there, and people are focusing, and there's only one place to focus. I think copyright and trademark are certainly areas where I think that it could be centralized, whether in the federal circuit or somewhere else. I think copyright more so than trademark. I think trademark's a little easier to flesh out, and the circuits are a little more consistent. But in those kinds of instances, I think another place we're seeing issues is we're seeing differences in circuits in certain antitrust questions, at least where antitrust intersects with intellectual property law, the things that relate to the Supreme Court's decision in Actavis, which is, full employment for antitrust lawyers. But I think that's one place that having circuits be different. I mean, the reason the Federal Circuit was formed is because some circuits were very patent friendly and other circuits, clearly didn't like patents. And so what you had was a lot of people running around the country trying to get into a forum where the particular circuit court had an apparent policy bent. So they wanted to stop the forum shopping. And they also didn't want a situation where a business couldn't operate on a nationwide basis because their patent is valid in the Sixth Circuit and invalid in the Ninth Circuit. Or it would be more likely invalid in the Eighth, I guess, back in the day. But so that's why it was formed. I think the same kind of problems do arise for businesses in other areas as well. I don't think we're going to go there, though. I mean, I really don't. We're never going to be England, I don't think.
Professor Boyden, you have a question?
Yes, I promise not to heckle. But during your talk, I was listening to it. I was looking for the rays of light in terms of reducing the cost of patent litigation, because I think that the cost of litigation is what is driving a lot of these issues. That drives the concern about for patent owners about the cost of actually enforcing those patents. It drives the concerns for defendants about patent trolls. And I'm curious where you think the first best solution might come from in bringing clarity to the doctrine, or is there something Congress could do? It seems that a lot of the efforts that the various institutions have taken lately, so Congress arguably hasn't brought a significant amount of clarity or predictability of patent law.
Well,
as the Supreme Court, I think it's probably fair to say.
This is actually one of the things that's a big part of that speech I give on the separation of powers. I don't think Congress needs to be doing this. It's happening right now. The Judicial Conference has proposals for changes in rules with respect to discovery, has proposals for getting rid of the forms for pleading in patent cases. The Judicial Conference, through its Rules Committee, is already working on this. We have local rules in almost every district that handles a lot of patent cases that are greatly streamlining how these cases are handled. We have the patent pilot program judges who are coming up with more standardized rules. We have some proposed model orders that a variety of academics, and including some of the lawyers that serve on our advisory committee for our court, have come up with, and that most districts are starting to follow with respect to limits on e-discovery, with respect to limits on a variety of other claim terms, for instance, how many claim terms you can assert and how many claim terms you can presumptively assert. There are proposed rules out right now from the Judicial Conference to reduce the number of presumptive depositions you can do in any case. So it's already happening. So I think that one of my biggest problems with what Congress is doing is they're being told that there are problems when there are already fixes in the works. And what they're going to do is impose fixes from the top down that are going to wipe out all the effort that's been made. And really, what a district court judge can do is to recognize that no two patent cases are the same, that this one doesn't need the same amount of everything as this one. And so we can handle it by streamlining the particular cases and streamlining the case to the particular facts. If something comes from Congress, we're never going to be able to do that. So I do think there is a huge ray of light. It's a whole nother speech, but I really do think there's a lot going on, and I think that it's sad that topic, that fact, is getting ignored in all these discussions on the Hill.
I think we should leave it at that. Let me say three things in conclusion. The first is that we will have a reception right outside in the Zilber Forum with lunch, and you are welcome to stay if there are particular questions that between bites to eat you want to press upon Judge O'Malley, but we're reluctant to ask here. I will not moderate the questions, but you are welcome to make the effort. Second, I want to thank all of you for attending this year's Nies lecture. This is a wonderful crowd in terms of the sorts of folks whom we have attracted, and in terms of the particular folks, not just the sorts that you fall into. And third, I want to especially thank Judge O'Malley for not only a wonderful Nies lecture in terms of its discussion of patent matters, but also for giving us a further sense of Judge Helen Wilson Nies, whom we remember every year. So thank you so much.